Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here. Jennifer Gathright. Kelly Gathright. Matthew Gould. Here. Samuel Molina. Here. Jesse Pearson. Valdemar Salinas. Valdemar Salinas. You want to see Mr. Harrison this morning? Over to Bobby Evans. He'd say how long? Marty McCormick. Kenneth Nash. Alexis Nava. Jason Nichols. Jeremy Snelson. Mr. Snelson, your attorney will not be here probably till 10 to 10:30. I think he's coming from another court. Okay. Joshua Chenault. Joshua Chenault. Monty Austin. Here. Taylor Davidson. Here. Warren Humes. Here. Tayameka Johnson. Here. Christopher Nash. Here. William Hayes. Here. All right, is there anyone who's present in the courtroom? I've not called your name. All right, do we have any attorneys that are ready? Mr. White, you ready? Yes. Who are you ready on, sir? All right, get Mr. Schmidt so that I make sure he's. Have you already talked to Mr. Schmidt?
I have, Your Honor.
We have it. You said you have it.
I have, Your Honor.
Okay, so
he's aware that I've been retained.
All right, so this is cause number CR 18-163, State versus Warren Earl Humes Jr. We were set on a motion to revoke, except for plea today. The court had found Mr. Humes indigent based on his application. Court appointed attorney. The court had appointed the Honorable Richard Schmidt. Mr. White, have you filed a motion to substitute counsel?
Yes, yeah.
All right. Court's going to grant the motion to substitute counsel. Court hereby enters the appearance of Mr. Nolan White into the record as counsel for Mr. Humes. Any announcements, Mr. White?
Your Honor, I'm just going to ask for reset.
How did Mr. Humes go from indigent to non-indigent for purposes of counsel?
Well, not going to too much into it. I'm waiting for him.
Mr. Humes, you understand that you're still going to be responsible for reimbursing Van Zandt County for the cost of Mr. Schmidt's legal. Do you understand that? Is there any objection to the request for a reset by Mr. White?
No, Your Honor.
All right, fourth one is set as Mr. Meetings for the contested docket on January 30th. That'll be at 9 AM. And Mr. White, this is Mr. Yoon's third appearance on a motion or a vote, so fortunately, I think you're gonna have enough time, but unfortunately, January 30th is gonna be the last day.
That's fine, Judge, I knew that, I'll agree.
We'll either need a resolution or a getting nothing, yes, sir. Probation extension on Pearson.
Yes.
You're free to go. Mr. Pearson. CR 19-243. Mr. Pearson, you're here today on a request to extend your period of probation, correct? And it looks like you're requesting to extend it for a period of 1 year. You understand that your current probation is set to expire here in about 11 days on December 10th.
I still have some payments, so.
Okay, so you believe if the court extends you for an additional 1 year, that's going to allow you to complete your probation requirements?
Plenty of time, so.
All right, and Mr. Pearson, you're requesting an extension of your own free will, meaning no one's threatened, force, or pressured you to do this, correct? Okay, all right, the court's going to find that Mr. Pearson is entitled to an extension. The court will find that's in the best interest of justice, and the court extends Mr. Jesse Pearson's period of probation for 1 year with a new expiration date of December 9th, 2024. All right, Mr. Pearson, if you'll come over here and meet with the probation officers, they'll get you a copy and give you information. For Mr. Rolls.
Morning,
Yes, sir. Mr. Hernandez.
Yes, sir.
Sign this here.
I mean,
Yes, sir, please. I think it's just a certificate of discovery. Oh, great. Morning. All right, Mr. Wells, Mr. Hayes, if you'll step up. This is cause numbers CR 22-306. 300, 301, 302, 303, 304, 305. Mr. Hayes, you'll raise your right hand, sir. I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thanks. Your name is William James Hayes Jr., correct? Yes. And Mr. Hayes, are you a United States citizen who reads, writes, and speaks English? Yes. Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Ron Wells. Are you pleased with Mr. Wells' representation? Feel like you've had enough time, and you have other counsel in this case as well, is that correct? Yes. You feel like you've had enough time to discuss your case with all of your attorneys to the point where you're satisfied that you've had all of your legal questions answered and that you understand everything that you've read, signed, and agreed to in this plea agreement? Yes. Mr. Wells, do you believe Mr. Hayes to be competent today?
I do, Judge.
And you've explained to him his rights as they pertain to this case, including the advantages and disadvantages of a deferred adjudication plea.
I have, Judge.
Do you believe that he understands those rights, he understands those risks, and that he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, let's see here. In cause number CR 22-306, you were indicted on the state jail felony offense of criminal mischief greater than $2,500 but less than $30,000. If you were to be convicted and sentenced, that does carry a range of punishment of not less than 6 months confinement with Texas Department of Criminal Justice and not more than 2 years. In addition, a fine of up to $10,000 could be imposed. I see the plea agreement in your case, Mr. Hayes, is that you intend to plead guilty to that criminal mischief offense. In exchange, the state's recommendation is that the court consider the evidence, but defer a finding of guilt. That means not convict you today. Rather, place you on 2 years of community supervision, assess a $4,000 fine, court costs, reimbursement, and there would be a weapons forfeiture in this case for the weapon seized. And in addition, as a special condition of community supervision, you would have to attend and complete anger management. It looks like the state is also, in all of the other cases that you've been indicted on, the daily conduct, abandoning, endangering child, all of those cases appear to be under the state's motion to dismiss. So it looks like all of those are being dismissed by the state with your plea in this one single count. Is that your understanding? Yes. All right. Understanding the plea agreement, understanding the range of punishment. I want to make sure that you understand. I know Mr. Wells has already explained it to you, but let me go ahead and mention it again on the record today. If the court approves this agreement and places you on deferred adjudication under the terms and conditions of community supervision, which you've had an opportunity to read over and sign, is that correct? Yes, sir. I'm not sure I do have the conditions of community supervision. Do you have those, Mr. Wells?
I do. Oh, that he's still facing.
Has he read over all of them?
Yes, sir. Yes, sir.
Okay. So, Mr. Hayes, you've read over these conditions of community supervision. You understand that a violation of any of these conditions could result in the state filing a motion to bring you back to court. They could ask the court to adjudicate your guilt. That means convict you of this offense. They could ask the court to revoke your community supervision and assess your punishment anywhere between that minimum 6 months prison up to 2 years upon a showing to this court and then proving that you violated the terms and conditions of your community supervision. You understand that? The issue of whether or not you committed criminal mischief would no longer be before the court. Sole issue would be, had you violated any of your conditions of community supervision. You understand that? That's because you're waiving your right to a jury trial, and you're waiving your right to cross-examine the state's evidence and witnesses in regards to the criminal mischief. Do you understand that? Understanding all of that and the inherent risks, you still wish to go forward. All right, Mr. Hayes, how do you plead to criminal mischief greater than $2,500, less than $30,000? Are you pleading guilty to that crime because you are guilty of committing that crime? Does anyone threaten, force, or pressure you to plead guilty here today? All right, the court does accept Mr. Hayes' plea of guilt. Mr. Wells, any objection to the stipulation of evidence in this matter?
No objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of Mr. Hayes' judicial confession. Anything further from the state?
No, Your Honor.
Any victim impact, victim compliance, victim agreement with this resolution?
Your Honor, an ANP was filed in this case. So we are in compliance.
So the victim has filed an affidavit of non-prosecution?
Yes, sir.
All right, anything further from the defense?
No objection.
All right, the court's going to review the evidence. I think I saw a note in the plea admonishments that there's no restitution in this judgment because that's already been satisfied. Is that correct?
It was paid in full, Judge, yes, forward and with at the same time that was done.
Thank you, Mr. Wilson. All right, then based on the court's review of the evidence, I do find sufficient evidence to convict Mr. Hayes of criminal mischief. Court will follow the plea agreement today based on the recommendation of the state and the agreement of the parties. Court hereby defers the finding of guilt and places Mr. Hayes on 2 years of community supervision, assesses a $4,000 fine, orders him to attend anger management as a condition of that community supervision. Court also finds that a weapon was seized with regards to this crime. Court hereby orders the forfeiture of the firearms. I think there's multiple firearms.
There were 3, Judge.
So the court's going to order the forfeiture of all of the firearms seized as reflected in the judgment. The court assesses court costs at $290, reimbursement fees at $35. Court is also granting the state's motions to dismiss the other remaining cases at this time. All right, Mr. Hayes, you hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of the sentence. Please come up here and see Deputy Martinez is going to be your fingerprint, and then the probation officers will tell you about what's next. Who else?
Either plan. Okay. I'll start designating those things out.
You need time, Mr. Schmidt, are you ready on anyone? Need some time? I've got some sanctions board I can take up.
Okay. What job?
Mr. Molina. Mr. Molina.
Sorry, oh, yeah, it's here.
No, I was calling you up here.
I'm sorry.
There you go. It's fine. All right, this is cause number CR 18-104, sanctions court hearing for Mr. Samuel Molina. All right, Mr. Molina, I have a note here that says that you admitted to driving a vehicle without a driver's license and without an interlock device.
Well, I don't have a truck. It's a company truck, to be honest with you. And I requested the in-home unit that I have, which I blow in. And my driver, who's 70 years old, has cancer. And I couldn't, I'm not trying to make excuses, but I have to work to pay the fines. And I was driving, I'm going to admit to that. But I have an in-home unit where I blow it home. I don't have an interlock on the truck. It's a company truck.
I can put an interlock on a company truck.
Well, the company don't want it on there.
I bet they don't want it on there, but they can't have you driving a company truck. You're on probation. DWI third or more.
Right.
Their insurance premiums would go through the roof if they knew that they had a felon driving their company truck who's under court order to not be driving at all because you don't have a driver's license.
Yes, sir.
Number one, you don't have a driver's license.
Right.
Number two, you're on court ordered felony probation to not be driving without an interlock and you're driving. If I said the name of that company right now on YouTube, I'm sure that they'd probably get dropped by their insurance carrier today. I'm not gonna do that. Because that puts you in the world of hurt.
Like I said, normally I have a driver. I just said it was one day and I didn't have a driver. I'm not gonna lie about it. And I drove him because I needed to pay my fines.
No, I understand the need to work and I understand the need to do that, but you have to understand that there's a need that you can't do that. Because that's that one day is now gonna cost you 3 days in jail. You understand?
Yes, sir.
You're gonna have to figure out a way to work. Get your driver's license back. If you
I
wanna,
got an appointment for February, and like I said, I do have a driver that comes and gets me every day now, so.
I appreciate that, but you're gonna have to be in compliance with all of these conditions. Until you get your driver's license back, number one.
Right.
So you're not committing a new crime, but you committed a crime by driving without a license. Okay, you're gonna have to get your driver's license back, and when you do, you get a vehicle, then we'll put an interlock device on it.
Right.
And then you can show me every time you drive, you can blow into it, and if you don't have any alcohol in your system, then hey, that car will fire right up and off you go to work and you won't have a problem.
I haven't had.
This is not a solution. This is a shortcut to prison. Is what this is.
Right.
Shortcut. This is fast track. I'll put you in the fast lane. We'll come in here, we'll have a hearing. All they gotta do is prove up. You don't have a driver's license, you already admitted to it. Bada boom, bada bing, off you go to prison, and I don't have to worry about you trying to shortcut my order. You understand?
Yes.
It's very serious.
Yes.
So I'm gonna give you an opportunity to let this be a small mistake rather than a mistake that takes away up to, let's see, you're on for.
30, right, felony probation.
I understand that. I'm trying to see, I think 7 years. You got a 7-year sentence. I believe.
I had 5 the first time, and I
So
realized,
whatever it is, it's a big part of your life.
right,
It'd be dumb to give that away. Okay,
so I've got 7 more years of this, is what you're telling
well,
me?
I'm sorry, your term was 7 years. It says you're supposed to expire in August of 2025. If you violate it again between now and then, you're looking at going to prison
Yes, sir, I understand.
much longer than that.
Okay,
So I'm gonna sanction you 3 days in jail for those 2 violations.
yes, sir.
All right, I'm gonna let you meet with,
It's already done.
oh, it's already done. So you're gonna go in this Friday night at 6 p.m. You're gonna sit in the jail until Sunday at 6 a.m.
You're talking about tomorrow?
I'm talking about tomorrow. Tomorrow night, 6 p.m. Get somebody to drive you up to the jail, bring your driver's license, so they'll book you in. Without photo ID, they're not gonna book you in.
I have an ID, I don't. have
ID,
one.
expired driver's license, something.
Right.
Right, something that's gonna show that you are Sandy Molina. And then they'll let you out Sunday at 6 a.m. I'm not even making you do a full, 3 days, hour for hour.
So it's tomorrow night at 6 p.m. Yes, sir.
Till Sunday at 6 a.m. And while you're in there, let's use that time to think about whether it was worth it to violate the conditions for this. All right? Awesome. All right, Mr. Molina, come over here and see Ms. Burns and she'll give you some. Harrison, are you ready?
Judge, I am. I've got a motion to withdraw the motion or vote.
Mr. Salinas, if you'll come forward. This is cause number CR 19-291, State versus Baltimore Enrique Salinas. Sorry, Mr. Harrison, go ahead.
I've got a statement, sign a motion to withdraw, motion for vote. Excited about your new coach.
Excited.
I think he's a good hire, actually. Yeah.
State, or so what's so you follow the motion to withdraw, the motion to adjudicate, and you're gonna continue, any modifications? What was the purpose of the motion? If we're just gonna withdraw and continue with no consequence for any violation.
Your Honor, the basis of the motion was a new theft charge out of Kaufman County, which we're expecting is gonna be dropped. In addition to some financial, falling behind in financial. I spoke, I believe Miss Griffith is the probation officer. I spoke, Miss Bryan, I'm sorry. Spoke with her yesterday. She explained that, Mr. Salinas, and correct me if I'm wrong, Mr. Harrison, his job is such that he gets, kind of paid by projects. So he'll make balloon payments.
We gotta talk one at a time, or my court reporter's hands are gonna fall off, so just let him finish, go ahead.
So as far as the financial failures, he makes balloon payments, and I believe he's down under $200 behind at this point. So he's made significant payments to catch up. In addition to the theft charge, we're expecting to be dropped by Kaufman County. And just in addition, Ms. Bryan did say that Mr. Salinas is attending extra counseling on his own and is very involved in working his probation.
So Ms. Bryant's she's supportive of this withdrawal and continue?
Yes, Your Honor.
All right,
I did speak to her on Tuesday afternoon, and everything you just said is correct.
all right. All right, Mr. Salinas, the court is granting the state's motion to withdraw the motion to adjudicate. You understand you're still on community supervision. This doesn't take you off probation.
Yes, sir.
It just means that you don't have a pending motion to revoke at this time, okay? All right, the court has signed that. The court is going to continue on community supervision. All right, you come over here and see Ms. Burns, and she can give you a copy of this if you need this for your records. Thank you, Mr. Harrison.
Thanks, Judge. Have a good weekend. Okay. See you next Thanksgiving.
It won't be that long, will it?
Yeah, they're playing at A&M first game.
Oh, that's right. That's right. Good luck if I can get in there.
I'm just thinking about a football sense, not a judicial sense of.
Yeah, no, I'm Mr. and Ms. Gathright? All right, I'm gonna bring y'all both up at the same time. Your husband and wife, correct? And y'all both got similar issues on sanctions courts. Figure we'll just talk about it at the same time. Let's go over a couple things here. Both of you are on probation for manufacture, delivery of controlled substance, first degree felony. Looks like you're both got on in just October 2021. You've got till 2031 on your probationary period. And there's a couple of issues. These are the notes that I'm getting from the probation department. For you, Mr. Gathright, if you're delinquent on your fees, your community service hours, you're way behind on those. Ms. Gathright, similar. I see that you're behind on your community service. They're indicating that you've got a medical issue. We'll talk about that. What's the issue on, let's first start talking about the community service. Mr. Gathright, what's the issue on community service? You've got 500 hours you have to do. You've worked 95 hours since getting on over 2 years ago. So you're almost 150 hours delinquent. Why we fall behind on that?
I'm working 7 days a week, getting my business built back up, and I'm working 6 days a week, physical work, and then my extra day, I'm out doing bids on jobs so I can keep the business rolling.
So what's your plan on how to comply with probation?
Well, I've got guys working for me now, and I finally got them trained to the point where I can actually break free on the bed and start this.
So where do you plan to do your community service?
We've got a place in Greenville that we found recently, for the Audi Martin. The Audi Martin, auditorium.
Is this something that you think you can start doing like this month?
Yes, sir.
Okay. And it looks like you're delinquent on your money as well, so I'm gonna infer that the reason you're behind is because of what you just said. You're trying to get your business up and going again, right?
Yes, sir.
We just caught them up, though. Their fees are current.
Y'all got caught up on your fees?
Yes, sir.
When did y'all do that?
We were struggling financially and I had a vehicle that was given to me. It was an old truck sitting out in the field that run. And I had told Ms. Griffith that I was trying to sell it to pay off to get current, and I just sold it, I guess about a week and a half ago, and I just paid them within the last week.
How much did you pay?
I believe mine was like 620 behind, and I think his was 5 something behind. And so every dime that I made from the vehicle, so I put it toward it.
Okay,
So they should be current as of now.
okay. And is that the only time that you've fallen behind on your fees?
Yes, sir. Well, I mean, it's, I mean, we've been behind for a while, but struggling to make it.
Going forward, do you think you can make your minimum monthly amount that you're ordered to do?
It would be nice if we could lower them to 50 instead of 100 and then pay extra if able. But I know that we could pay 50 a month versus 100 a month. It's just hard to do that with me working less too because of my medical condition, and then he's working 7 days a week to make up for me not being able to work. So I mean, I know that we could do 50 for sure, but it's a struggle to do the 100 each.
Tell me about your community service. You said you got some medical issues. Are you able to do, says here that they instructed you to do light duty community service, like bell ringing for
Yes.
Salvation Army and things like that?
I can, I don't know how I can't stand for like 5 hours. But
Will
and
they
I
let
do,
Will they let you bring a chair and sit by the bell?
I don't know if they'll let me bring a chair or not. I emailed the probation officer in Hunt County yesterday about that, and he hasn't responded yet. I did have two doctors notes saying that I couldn't do community service, but she was trying to see if I could do light duty.
Do you
So
expect,
I am working on that.
do you expect your medical condition to improve?
No, it never will. It's, I have Hashimoto's and I also have fibromyalgia. And
So are you working, it says here that you haven't provided enough medical documentation to your probation officers in order for them to be able to review all that and determine whether or not your community service can be waived. Are you working on that?
It says I have or have not.
Have not. Says you have not submitted enough. Doesn't say none, it says you haven't submitted enough for them to be comfortable that they could waive or request that your community service be waived.
The last that I was aware of, she wanted a letter, stating why I couldn't do it, and I have letters from two different doctors, a rheumatologist and my primary care, saying that I couldn't do it because the fibromyalgia causes chronic pain. I'm not sure what else I can provide.
Okay.
I'm not sure what else they want. I had given her a letter once and it just said that I'm due to fibromyalgia, but then she said, I needed to provide why. And then the next two letters said because of the fibromyalgia causing chronic pain. I'm not sure what else I can provide.
Okay. You know what can you point out what their correct fees are? So if they're saying that they're caught up, like what do they order to pay on fines and probation fees? All right, do me a favor, have a seat. I'm gonna take up some other cases and then we'll talk about community service and fine things, okay? Have a seat on that first row is fine. Let me take up a couple of the cases and then I'll call you back up. Man, are you ready? Yes. Who are you ready on, sir? Mika Johnson, you're coming forward, ma'am. This is call number CR 21-296. All right. Is the state's motion to adjudicate. I see that the state has filed a motion to withdraw its motion to adjudicate, requesting that Ms. Johnson be continued on community supervision with 2 days in the county jail as a condition of community supervision. Her receiving credit for those 2 days time already served. Is that correct?
Yes, Your Honor.
And what are we doing to address the motion to adjudicate?
I'm sorry, Your Honor. As far as the counts. So
I'm saying you file a motion to adjudicate, and then now you've withdrawn it to just continue her on probation. And giving her 2 days of time that she already spent in jail in the past. And it looks like there's an order to pay things that have already been ordered. So I guess I'm asking, what are we doing to address the issue, or why are we filing the motion? Mr. Schmidt?
Well, Judge, I do know that the count one as alleged was resolved. So that was the big one. The rest were technicals. And the technical, she had one reporting day, month. But the technicals basically were money, and it's my understanding Ms. Johnson's been working diligently to get caught up and get all that stuff back on track. And so it's my opinion that absent count one, the state would not have liked to file this. So from that perspective, I think Ms. Johnson has been diligently working to get herself on track so that we're not in this position again.
Right.
And Your Honor, if I could add, I was mistaken earlier. This is Miss Griffith is the probation officer. I did speak with Miss Griffith about this. She said, Miss Griffith did point out that Miss Johnson is behind delinquent in her, community service hours. But otherwise, she's in compliance, and she was in agreement with reinstating Miss Johnson on probation. If the community service hours become an issue, it may result in a amendment to conditions of probation to extend or something like that. But as far as reinstating, Ms. Griffith was supportive.
And you said, Mr. Schmidt, that count one, the theft allegation, that's been resolved.
It has been, Judge, and it was a Class C misdemeanor charge. I think it's been resolved in, or it was a fine only.
All right, the court will grant the state's motion to withdraw its motion to adjudicate, finds that the probation department is supportive of continuing Ms. Johnson on community supervision. Court grants the motion to withdraw, continues her, amends her community supervision to reflect the amendments shown on the form to condition, one and condition. All right, Ms. Johnson, if you'll come over and see Officer Ventura, she'll give you some information, get copies, and you're free to go.
Pace, maybe 16 to probation and 45 to court each.
Okay.
And they all. Each. I'll have to go check with them. It's maybe.
All right, Mr. Strand, who else?
Christopher Nash,
Yes, Christopher Nash. All right, Mr. Nash, if you'll raise your right hand, this is cause number CR 21-388. Mr. Nash, do you swear that the testimony you give to the court today is the truth, the whole truth, nothing but the truth, so help you God? You can lower your hand. All right, Mr. Nash, I see here that you want to waive your right to a jury trial, is that correct? You talked to Mr. Schmidt about what it means to waive your right to a jury trial. You understand that no one can take that right away from you. You have the right to require the state to prove their case beyond a reasonable doubt in front of a jury of your peers. You understand that during that trial, you have the right to cross-examine their witnesses, confront them, and contest their evidence. You understand that if you waive your right to a jury trial, that right may not be restored to you later. Meaning that if you change your mind at the time that you want to enter into a plea, then you do not have that right to a jury trial anymore. You have the right to a bench trial. That means right before a trial before the courts. And you discussed this with Mr. Schmidt, and you are wanting to waive your right to a jury trial based on your own free will. Meaning that no one's threatened you, forced you, pressured you, told you that you had to make this decision today. Mr. Schmidt, you join in with Mr. Nash on waiving his right to a jury trial.
I do, Judge, and we know for the court that Mr. Nash, I believe, is set number 4 or 3 on the December 4th docket. That's why we've asked for the setting today.
All right, thank you, Mr. Schmidt. And Mr. Hernandez, on behalf of the state, is the state waiving its right to a jury trial?
Yes, Your Honor.
All right, I'm gonna have you sign that in just a moment. All right, the court finding that Mr. Nash has been admonished as to his right to a jury trial, finds that he has intentionally, knowingly, and voluntarily waived the same. The court finds he's joined by counsel, and that the state of Texas has also waived its right to a jury trial. All right, so we're sign this, and we need to set this for a plea, is that correct?
Yes, sir. We'd ask for the January 16th docket, set the plea at 1:30.
All right, well, we'll set Mr. Nash for January 16th, we said at 1:30? At 1:30 p.m. Mr. Smith, are you ready on that?
Austin.
Mr. Austin, do come forward, sir. CR 22-166. Motion to adjudicate. Go ahead, Mr. Smith.
Seven. I received a statement of it's going discuss a resolution with Mr. Carlisle. Freeze for us.
All right, court will set a final hearing on the motion to revoke on January 30th, 2020. You may.
Thank you. Well.
All right, so this is what I'm gonna order. I'm gonna order y'all to come back. in January on Stations Court. We'll come back on. January 16th. This is what I want y'all to have done before you get back, okay? I want each one of you to pay $60 in probation fees. That's your amount, okay? $60 for probation, $60 for your court collections. Okay, originally, before we knew that you had paid off the balance. It was gonna be 100 in probation, 75 court collections, so I adjusted that down because you said it was, so 60 probation, 60 court collections. Mr. Gathright, I need you to do at least 10 hours community service. We're probably gonna have to, at some point, bump that up. So we can caught up, we give it a little bit of time, so I didn't do 15, 20 hours. 10. All right, that's 2 half Saturdays, 1 full Saturdays. All right. So we'll figure that out. Miss Gathright, same payment, 60 to 60 each. And then on community service, I want, I tell you what, I'm not gonna do community service this time. I'm gonna ask the probation department to go into the paperwork that you provided. If they want something additional, I'll tell them exactly what it is they want from you. And I want you to get it from your doctors, your healthcare providers, and bring it back for the next school meeting, okay? So we'll see you back, next week, we'll be back, I'll give you notice of settings here on January 16th. I expect $120 for each one of you on your probation, of your court elections, 10 hours, Mr. Gathright on your community service. Okay. You all have any questions? Before you leave? All right, see you back in January.
Thank you.
All right, court's gonna stand in recess for about 20 minutes to give Mr. Manning and Mr. Schmidt an opportunity to keep working with the clients, and we'll wait on Mr. Sanders as well. All right. So you don't have to stay in the courtroom, you can mill about, so just check back in about 10:40 or so, okay? Mr. Davidson, if you'll come forward. All right, this is cause number CR 22-94, state of Texas versus Taylor Davidson. Mr. Davidson, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today was the truth, the whole truth, and nothing but the truth? So help you God. Thank you, sir. You can lower your hand. All right, Mr. Davidson, you are set for jury trial next week, but it's my understanding that at this time you want to waive that jury trial and you want to resolve your case by a plea agreement. Is that correct? Sir. Okay. And have you had enough time to talk with your attorney, Mr. Schmidt, about what it means to waive your right for jury trial?
Yes, sir.
Okay. Do you understand, Mr. Davidson, that no one can take that right away from you? Mr. Schmidt can, I can, the state can, only you. And you can only do so if you're doing it of your own free will and accord, if you're doing it intentionally, knowingly, voluntarily. Do you understand that? Yes, sir. And you understand that if you waive your right to jury trial, it will not be restored to you later if you change your mind at the time that you want to enter into a plea. If you change your mind and you don't want to enter into a plea, then you also have that right, but you will have waived the right to a jury trial, meaning your only resort would be to have the case tried before the court and a judge would have to make the decision in your case. You understand? Yes, sir. So understanding that you still wish to go forward and waive your right to a jury trial today. Sure. Mr. Schmidt, you believe Mr. Davidson is entering into this intentionally, knowingly, and voluntarily. All right, and the court finds that the state has signed indicating waiver of its right of jury trial in this matter as well. Court hereby finding that Mr. Davidson has been admonished as to his right to jury trial, the court waives that right, approves the waiver of that right, and signs the waiver of jury trial. And judge yeah, no, Mr. West gave that to me on my request. And I would ask that all right, court says Mr. Davidson enter his plea January 16th, 2024 at 1:30. So Mr. Davidson, you'll report out to the Van County Jail, the Justice Center, to do that plea, okay? Yes, sir. All right, once you sign, get your notice of appearance, ready to go. Man, be ready. Judge, really. Evans. Bobby Lynn Evans. CR 22-271. Go ahead.
Judge, received an offer to resolve this case yesterday. It is first time, so I was request an opportunity to discuss on my client. I waited for the bonds. He is my client's requested negotiations on this case, so let's see if I can create a solution. At this point in time, we request to be set off for the next docket. I believe that next test docket is that in December or is that in January?
It will be in January. Remind me, you were just recently appointed on this case, is that correct?
Judge, I believe made one appearance prior to this on the case. But I just got my offer. I was appointed on 10/24 and I just got the first offer yesterday.
All right, court will set Mr. Evans for a final hearing on the contested docket for his motion to revoke January 30th at 9 a.m. Either that day we'll have an agreement or we'll have a contested hearing or the state will withdraw its motion. All right, free to go, sir.
Judge, next we're ready on Mr. Marty McCormick.
Marty Glenn McCormick, CR 23-188. All right, Mr. McCormick is set for arraignment today, is that correct?
Yes, Judge. We received a copy of the indictment this morning, and I've requested discovery on the case. Mr. McCormick understands the charge against him. His name is spelled correctly, and his plea is not guilty. Request to be set on the pretrial docket.
All right, court will enter Mr. McCormick's plea of not guilty into the record, finds that he has waived the formal requirements of arraignment. Court will set this matter for pre-trial hearing on the available January 18th.
Judge, I am in trial in the 86th District Court that week.
What about Thursday, January 4th?
Judge, that will work.
All right, January 4th.
Judge, I would say though, because of the nature of this case and the fact we haven't had discovery, I would request, if possible, a little bit longer, or if we do reset it to the 4th, give an allowance to possibly kick that out a little bit longer than that.
I would have to go into February 1st.
Judge, if that's all right, that would work better.
Court will set Mr. McCormick for pre-trial February 1st. And I do show that Mr. McCormick is delinquent on his pre-trial release $240. Mr. McCormick, you gonna be able to pay any of that today?
I is towards the end of the month.
Okay, well, you're delinquent $240, so let's get that caught up as soon as possible. Can you make any kind of payment today? Okay, but if you can make any payment today, I want you to go over and do that at the probation point. Okay, I will see you back on February 1st.
Next, Judge, we're ready on Mr. Kenneth Nash.
Mr. Nash, if you come forward, CR 22-71. All right, Mr. Manning, the court has reviewed your motion for reconsideration of amended conditions and request for reasonable modification of condition. I see in paragraph 5, you requested, or you at least indicated that you don't have access to the results of any polygraph or psychological examinations regarding the modification of the conditions in this matter. The court has directed the Community Supervision Corrections Department to provide, I think that you've already received the psychological examination. If not, you'll receive that, and the court has directed them to give you the results of the polygraph examination as well.
And Judge, I can note for the record that since I have filed this, I've received both the psychological and the polygraph examinations.
Okay. So the only other issue that the court wants to take up that's not reflected in your motion is that Mr. Nash has made a claim of actual innocence to, I believe, the polygrapher or the expert doing a psychological examination. So what I want to do is set this off and give you some time to explore that with Mr. Nash, so we can determine what the next step is, whether there's going to be a hearing on involuntariness of his plea, testimony from his previous attorney, all of those facets that the court would have to undertake to address his claim.
And Judge, the only other thing left unfinished with the request that we made in our motion is that Mr. Nash, in effort to comply with the new conditions that have been put on him, is having difficulty locating a place that he can reside as he attempts to pay probation fees and comply with conditions of probation. And so we've requested that he be allowed to stay, that we modify condition, one of the conditions, I believe it is condition BB, I'm sorry, not, condition. His father, which with whom he would intend to reside, lives across the street from the Montessori school. My client has already spoken to the owner of that establishment. He is not, my client would be at work during the day when the children would be at the school. And he is requesting that we modify condition II to allow him to live at a specific address there, as I said, with the approval of both the school and his father.
Do you have some kind of approval from the school in writing that the board would apply?
I do not, as this was pretty fast developing, I do not have that at this point in time. But I imagine we should be able to get that if that would make the court feel better. It's just, my client is attempting to balance several different interests, and being homeless doesn't help any of those to be accomplished. I think, given a stable home environment, he should be able to comply with the conditions that have been added on him, as well as the conditions that were previously added. But with him being unable to know where he's gonna be sleeping.
The court will take that under consideration, if you will supply the court with some written documentation confirming the acquiescence of the school children across the street, then I will take that into consideration.
Okay, excellent, Judge. And I believe that at this point in time, answers all the questions that we've raised in our motion for reconsideration. I guess. Will the court make a formal ruling on that motion, or do you want me to submit an order?
On the modification of II,
Yes, Judge.
once you submit that in written documentation from the school, then the court will make that ruling without hearing. Okay, and I'll just tell you, I would probably intend to grant that as long as I get confirmation from the school that they understand that there's a risk, accepting that risk. That way, no parents in any school are gonna get upset at me, judge, for sending someone over there that I think has sex offender issues.
When would we like to reset this for the status and preparation for claims of actual innocence?
Let's set it on the contested docket in February. That'd be February 29th. I feel like that gives you sufficient time to.
Yes, Judge. And with the receipt of those requested documents, I'll have an opportunity to sit down with my client and discuss those in depth.
So where is he staying now?
A hotel, Judge.
Okay, so the sooner you get that, the sooner you get to me, the sooner I'll make a ruling that could help you in that issue. Yes.
Judge, next I believe we have Mr. Nava.
Alexis Nava, CR 2185.
Judge, may I approach?
All right, Mr. Nava, and sir, if you'll raise your right hand, I'm gonna place you on oath. You swear that the testimony you give before today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, Mr. Nava. You appeared before the court previously. Is the motion to adjudicate not a part of the agreement anymore?
It is, Judge, it was attached, it was cross-hatched on the back there. There should be a motion to withdraw, as well as to modify.
Said the motion, I'm talking about the motion to adjudicate, the actual motion. Is this not a motion to adjudicate, please?
No, Judge, this is we had previously filed a motion withdraw and continue with modification of its conditions. There was a new offense that was still being determined what they were going to, what the DA's office was going to proceed with. We discussed and they've been able to get filed a offense report to resolve the misdemeanor as well as getting Mr. Nava back on probation with the conditions that needed to be modified.
And probation is supportive of this plea?
Judge, they were supportive of it when we initially offered. I imagine, I haven't talked to him since we added this additional plea to the misdemeanor. I imagine it wouldn't change the tenor of our agreement.
All right, Mr. Nava, in cause number CR 23230, you were charged by information with a Class A misdemeanor offense of assault causes bodily injury of a family member. You're represented by your attorney, Mr. Manning, in both that case and in the motion to revoke case. Are you pleased with Mr. Manning's representation? Like you had enough time to talk to him about both of these cases, to have all your legal questions answered? Yes. Is there anything about the paperwork and the plea agreement that you've read and signed that you do not understand?
Sir.
In the misdemeanor assault case, looks like the plea agreement is you're going to plead guilty to that charge. The state is recommending that the court consider the evidence, find you guilty, assess your punishment at 91 days confinement in the county jail, issuing you credit for 91 days of time already served in the jail, a $100 fine plus court costs and reimbursement. And it appears in the felony revocation case, the state's was asking the court to grant the withdrawal of its motion, continue you on community supervision, order you to serve 93 days in county jail, giving you credit for time that you've already served. In addition, you will serve an additional 30 days on top of that 93 days at various dates that you agreed to that's laid out in this motion. Is that your understanding of the plea agreement? Yes, sir. The range of punishment for a misdemeanor assault of Class A is up to 365 days in the county jail and up to a $4,000. Understanding the plea agreement and the range of punishment, the court finds that this proposed plea would fit within the range of punishment. Mr. Nava, how do you plead to assault causes bodily injury of a family? Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
Court accepts Mr. Nava's plea of guilt in this matter. Mr. Manning, any objections to the stipulation of evidence?
No objection to the stipulation of evidence, Judge.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the statement?
Your Honor, just that we are in compliance on the assault case. The alleged victim in the case filed an affidavit of non-prosecution.
All right, thank you, Mr. Sherwood. Anything further from the defense?
Yes, Judge, I just would note that at our prior setting, there was an agreement for Mr. Nava to continue and be on the mental health caseload. And so we think that will help address some of what led to this offense. Additionally, Judge, my client has agreed to additional days in jail, and he will be turning himself in tomorrow for that to begin his 30 days serve out.
Thank you, Mr. Manning. Also, the new attorney fees is being taken into consideration in the felony probation case, correct?
Judge, I did not check that. I believe.
I think this was said 500.
I believe it said that in there. And if not, I'll waive my fee for this.
No, I think it's in here. I just want to make sure that this was this $500. All right, then based on the evidence, court has reviewed the stipulation of evidence, finds that there is enough evidence to convict Mr. Nava of this offense. Court does follow the plea agreement today, convicts Alexis Nava of Class A assault of family violence. Assesses punishment in accordance with the plea agreement at 91 days confinement in county jail. Court issues Mr. Nava a credit for 91 days of time served. Court orders him to pay a $100 fine, $270 court cost, $15 reimbursement fees. In cause number CR 20-185, court grants the state's motion to withdraw the motion to revoke. Court amends the community supervision conditions to include additional costs for $500 legal attorney fees. In addition, the court orders Mr. Nava to serve 123 days confinement of the Manzan County Jail, and receiving credit for 93 days of time served, and to serve an additional 30 days on the dates indicated in the amendments to conditions of community supervision. So, Mr. Nava, when you do go to the Manzan County Jail to serve your sentence, you need to have some type of photographic ID with you. Otherwise, they're not gonna let you. My advice is to take a copy of all of this paperwork with you, along with your photo ID. Saw a discrepancy. The amendment says 93 days, the police says 91 days. I think I pronounced 123 days based on this. Should this say 91 days instead of 93? Okay.
Judge, my understanding is they're eating up his back time. So he had the 2 days that he was originally in, plus the 90 or 91 that he served.
Okay, so that 91 days is being taken care of here, but we're also taking away any back time credit on that short.
That's
So it is 123 days total, 93 credit, 30 to serve.
yes, Judge.
All right, Mr. Nava, you hereby remain in the custody of the probation department, so you can carry out the terms and conditions of the sentence. We'll have you come forward to the Community Protector Martinez, and then the probation officers will give you information about what's. All right, Mr. Manning, who's next?
Judge, ready next on Mr. Jason Nichols.
CR 21-87. All right, so this is the status on Mr. Nichols' discharge from, I guess I think I recall we did a pre-trial intervention contract here that was based on, being a veteran program.
Judge, that is my understanding as well. I had an opportunity this morning to visit with both my client and his previous attorney, Mr. Casey Ashmore. I was able to get a fair sense of the situation, as well as some potential mitigation exculpatory information to provide to the state. We would request that this be reset for us to give an opportunity to negotiate with the state, as well as to examine our options. At this time, the state has made an offer to resolve this case, but we're requesting opportunity to provide.
January 4th.
Judge, that'll be fine.
Any objections, mistake?
No, Your Honor.
All right, court will set Mr. Nichols, I guess. We'll have to set a docket call, basically, is the way it is, correct?
I'm sorry, Judge.
Set a docket call. Announce it on the agreement. But the trial. I think it's a free trial, being played back on docket.
Well, my understanding, maybe my assent to the court's right. My understanding was it wasn't a PTI that was done here, but it was a mission into the Veterans Court in
I believe it was, let me look it up, but pretty sure that's. Mr. Ashmore wanted this court to defer its case to basically Kaufman County for them to handle. So I didn't know how this court would have jurisdiction to do that. So my recollection was that we did a PTI here with one of the conditions being that he successfully complete the Veterans Court program in Kaufman County. Let me refresh my recollection.
And then, Judge, if that was the case, that would help explain more some of the questions I had for Mr. Ashmore as to the jurisdiction of the case. I just don't have a copy of that.
Yeah, I'm gonna print you a copy of it.
Okay.
It says it's a non-reporting pre-trial intervention contract. You're gonna see it says in the county court of law, but it was actually done here.
Okay.
In the 294, back on November 4th of 22, so. I'm gonna print that to Ms. Taylor. I'm sure you're gonna make copies. Perfect. All right, so we'll set this for docket call on January 4th at 9 a.m.
And Judge, just to make sure that I've advised my client correctly, because he is not currently on probation or or the Veterans Court, his only conditions would be his conditions of bond, is that correct?
Correct.
Finally, Judge, it looks like I was just appointed on Mr. Gould's case.
Yes. Mr. Gould, if you'll come forward. It's called number CR 20-389, State versus Management on Gould. Court finds that Mr. Gould is indigent for the purposes of court appointed counsel. Court has appointed the Honorable John Manning to represent Mr. Gould. Court will reset this for the contested docket on January 30th. 2024 at 9 a.m.
Thank you, Judge. I believe that concludes my business report.
Did you find out about Mr. Chanel?
There's been a approach on that.
Yes, sir. One, Mr. Shelton. It's file number CR 23-119, CR 23-120. Mr. Nelson, if you'll raise your right hand, I'll place you on those. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, your name is Jeremy Lynn Snell, correct? Correct. Mr. Nelson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with Mr. Sanders and the work that's done?
Yes, sir, I am.
Feel like you've had enough time to talk with him about both of your cases, and you're satisfied, you've had legal questions answered, and that you understand everything you've read and signed in these papers.
Yes, sir.
Mr. Sanders, do you believe Mr. Snelson to be competent?
Yes, sir, I believe he is.
And you've explained to him his rights as they pertain to both of these cases?
Yes, Your Honor.
You believe that he understands those rights, and he's entering into these pleas intentionally knowingly involved?
Yes, sir, I believe he is.
Mr. Snelson, in cause number CR 23-120, you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon. That does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. I see the plea agreement is that you would plead guilty. The state's recommending your conviction plus sentence of 6 years confinement in prison, with that sentence being suspended and being placed on probation for 6 years, a weapon forfeiture, fine, court cost, and reimbursement fees. Is that your understanding?
Yes, sir.
In the other case, which is a taking wildlife resources without consent, that is a class A misdemeanor, carries a range of punishment of not more than 365 days in county jail and a fine not to exceed $4,000. In that offense, it looks like the agreement is that you plead guilty, punishment would be 2 days confinement in the county jail. You would get credit for those 2 days of time already served. You'd also have to pay court costs and reimbursement fees. Is it your understanding of the agreement in that case?
Yes, sir.
Understanding the plea agreement, understanding ranges of punishment. Mr. Snelson, I'm going to ask you this time, have you pleaded to unlawful possession of firearm by felon?
Guilty.
How do you plead to taking wildlife resources without consent?
Guilty.
Are you pleading guilty to each one of those crimes because you are guilty of committing each crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to either crime?
No, sir.
Court accepts the defendant's plea of guilt in each case. Mr. Sanders, any objections to the stipulation of evidence in each case?
No, Your Honor, no objection.
Stipulation is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Court's going to review the evidence. All right, having reviewed the evidence, the court finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement in each case. In the unlawful possession of firearm by felon, the court convicts Mr. Snelson of that offense, assesses punishment at 6 years confinement. The Texas Department of Criminal Justice suspends that sentence, places him on 6 years community supervision, orders him to pay a $2,000 fine, and the court orders the forfeiture of the weapon seized in that matter. In addition, the court orders Mr. Snelson to pay $290 court costs and $35 reimbursement fees in addition to the fine. In cause number CR 23-119, the court convicts Mr. Snelson of taking wildlife resources without consent, a class A misdemeanor, assesses his punishment at 2 days confinement in the county jail. The court will give credit for 2 days of time already served. In addition, the court orders that he pay court costs of $270 and reimbursement fees of $35. All right, Mr. Snelson, if you will come forward to be fingerprinted by our team here. When we're being to the custody of the Banzai County Probation Department, we're going to carry out the terms and conditions of the sentence.
Hey, Judge, one matter I did want to bring up. There's not any condition of probation saying that he can't have any contact with the property owners. I don't, at least nothing was in there. There was a
tree stand, some of that property was still on landowner's property. Is there an issue with him contacting them and seeing if either they can go and get that for him, or if he can have permission to go on the property to get his tree stand? And I think there may have been some game cameras that had been set up there that weren't ever retrieved.
You said that there's nothing in the conditions of community supervision.
Right, there wasn't anything in there. I just wanted to bring it up just so that if you made contact with the landowners, that there wouldn't be any problem.
There's no condition, then there'd be no restriction from a condition perspective.
Okay.
I would just advise him to handle that very delicately. And it doesn't go his way, and then he needs to understand that he brought that on himself. Could expect a whole lot of, if I was looking at it, I wouldn't be like that. But that's me. So I come up here and see Deputy Martinez. I think that concludes our morning docket. The court's going to stand in recess until 1:30. Board will be having a docket.